Welcome back to this session. So in our last session, we were looking at African customary law as a source of nature, as a source of law. And we were looking at section 2 of the Kenya Magistrates Court Act, which provides for areas in which customary law can be taken as a source of law in court. The circumstances under which a court can regard customary law as a source of law. So we are looking at the different cases, and we had seen number one is land held under customary law. Number two, matters of marriage, divorce, maintenance, or dowry. We had seen matters of seduction of an unmarried woman, or seduction or pregnancy of an unmarried woman or girl. We had also seen enticement or for adultery with a married woman. And we had seen matters affecting status, in particular the status of women, widows, children, and matters guardianship, custody, adoption, and legitimacy. So under this, so the customary law is more or less concerned with the relationship between persons in the community. So it refers to the status of women, widows, and children, which is used mainly to look at matters of succession. So in matters of succession, the first thing they want to know is who are your dependents. And dependents, much of who a dependent becomes is under customary law. So it is in this case where they will want to know who are the children of the deceased, who are the legitimate children, who are the children who are born out of wedlock. So matters of this nature will require the import of customary law when a court is deciding matters of this nature. It is important to note that many of these areas have now found their way into the Law of Succession Act. And therefore, the requirement of using customary law has been overtaken by events in most of these scenarios. So it also applies in matters of succession, in both tested succession and intested succession, as well as administration of estates. So where other laws are silent on an issue is when these laws are going to apply. So they're not going to apply so that they become contrary or inconsistent with the Law of Succession Act. They'll only apply where other sources of law are silent on the provision to apply. Now, we have a question here. State 4 characteristics that a custom and a customary law should satisfy in order to be enforceable. So this is a question that features very prominently in examinations. And I think this is important for you. So the rule or the custom, it needs to have existed from time immemorial. So in this case, basically the subjects are usually people who most likely were born never knowing when this custom began. So since they don't know when the custom began, they don't even know where it was brought up from, all they need to do is to follow it. So it is a long-standing practice that has become influential to the lives of people, and it's so influential are they that people have practiced them to a level that they become like the law. They feel bound by these customs. Number two, it has to be just and it has to be moral. It has to be just and it has to be moral. Because the Constitution says that these practices do not apply, or they only apply to the extent that they are not repugnant to justice and morality. So it is derived straight from the Constitution that they have to be just and they have to be moral. And also they must be consistent with written law. So these customary laws should never be contrary to the written law. For example, in counties or areas that practice, or communities that practice female genital mutilation, since there's already a whole act of parliament that prohibits female genital mutilation, that custom can never be relied upon in court. It is a custom that has been overtaken by the law or by written law, and therefore it is never going to be practiced as a custom, or at least in a legal manner. Then it must be generally accepted as binding. So the community where you come from, in your African customary community, is that this community must have accepted it as a binding custom. So you'll have to lead evidence in court where you are trying to show that these requirements have been met. Where one of them is that it must have been accepted generally as being binding on everyone. So the binding aspect has to apply. So if it is not binding or hasn't gained general acceptance or being accepted by the people, this general acceptance is very important in order to make it a law. So if it hasn't gained that, it is not going to be applied as a custom. Then it must be reasonable. And I'm going to advise you to read the SM Otieno case. This is a matter that went up to the Court of Appeal, and it highlights the application of customary law in a matter where there was a burial dispute between whether the deceased was going to be buried in Upper Matasia or his home in Luo Nyanza. So next we're looking at Islamic law as a source of law. And this is going to be our last source of law. So Islamic law is derived mainly from the Holy Quran as revealed to Prophet Muhammad by Allah. So the Quran is the main source of Islamic law. Other sources of law would include the Hadith. So the Hadith is are the revelations of Islamic prophets. So the prophets were told about some of these Sharia laws, and therefore those matters that they prophesied about have found their way into Islamic law. The other source is the Sunnah. The Sunnah basically contains the actions of these prophets, and these actions have found their way into law because people would want to emulate their prophets. The other one is the fatwa. And fatwa, these are the writings by scholars in Islamic law. And these scholars, they say what is known to them as Islamic law. So whatever they say, and since they have earned respect in that area, what they say is regarded as what the law is. So this applies, they apply in Qadhi's court, which is a subordinate court. The Qadhi's court is a subordinate court under the Qadhi's Court Act. So it is subordinate to the High Court, and it has its own rules of procedure, which are supplemented by the civil procedure rules. So if you have a matter relating to Islamic law and it is in court, you're going to realize that if you're going to the Qadhi's court is able to apply this Islamic law. So it applies in cases where both parties profess Islamic faith and the disputes should be in relation to some of the following. So where both parties profess Islamic faith and the issue is an issue of personal status. And personal status is a general term for these others. Matters like marriage, matters like divorce, and matters of succession and inheritance. So personal status is what they apply when deciding matters of marriage, divorce, and succession. So like somebody's wives, what are the rules of recognizing that somebody is a wife of another? Children, what are the ways of recognizing that someone is a child of a Muslim? So they'll apply on these matters, only on these 4 matters. So if you have a criminal case, do not take it to Kadhi's court. It will not decide it. And if it does decide, it is going to be against the law to make such a decision. And without having jurisdiction, a court is powerless over the matter before it. Now, that is the end of our class on sources of law. Now, next we're going to discuss administrative law. See you in the administrative law class. I've been your lecturer, Derek Mooma.